recording. Good morning, everyone. Welcome today to Alternatives to Conservatorship. And this is presented today by Disability Rights California. Thank you for joining today. I am Diana Schulach from Family Focus Resource Center. We have offices in the North LA County Regional Center catchment area, which is San Fernando Valley, Antelope Valley, and Santa Clarita Valley. We help families that have children and young adults with disabilities. And part of the way we do outreach is by having these wonderful, informative workshops that help our community. And today we are joined by Senior Attorney Maria Iriarte, who's going to be doing this presentation. But right now, I'm going to turn this over to Mari Cruz, who's going to do a little intro. Thank you, Mari Cruz. Thank you, everyone, for being here today.
Of course, thank you for inviting us. Good morning, everyone. So I'm just going to do a quick introduction of our agency so that you all know who we are. So Disability Rights California it's formerly known as Protection and Advocacy. It was funded in 1978. Governor Brown designated Disability Rights California as the Protection and Advocacy organization for people with disabilities. Each state and territory has the protection and advocacy system. California is one of the largest disability rights organizations in the nation. Disability Rights California passionately advocate for rights of people with disabilities by litigating, legislating, investigating, educating, and representing clients. We have over 260 employees throughout California. Our regional offices are located in Sacramento, Los Angeles, the Bay Area, and San Diego. We do have smaller offices in Fresno, Ontario, and Modesto. We receive funding through 9 federal protection and advocacy programs, and also from 2 contracts with the state bar. Thank you all for joining us, and I'll pass the microphone to Maria now.
Okay, thank you. Sorry, I've been dealing with this PowerPoint. So today the main focus of the training is going to be to talk about alternatives to conservatorship. The information we're giving you today is current, but it can change. So down the line, if you want to know more about this, you should look at other sources of information too, to make sure that what is here is current. So I'm going to talk a little bit about what a conservatorship does and doesn't do, why people are seeking conservatorship, the risks of conservatorship, and talking about capacity and different ways of thinking about capacity. And then we're going to talk about an alternative to conservatorship, which is supported decision-making and how it fits into the healthcare decisions, education decisions, financial decisions. So along with supported decision-making in these areas, we're also going to talk about other alternatives that can be used in addition to supported decision-making in these areas of healthcare, education, and finance. So these are questions that, if you ask yourself, you probably would say, you wouldn't like this to happen to you. Like the decisions that you make in your life are questioned by people who are close to you. Whatever choices you made is quote unquote evidence of your decision-making capacity. Maybe you made bad choices like we all do in our lives. And then that could be used to say, oh, you don't have the capacity to make decisions. Or concerns about your health and safety are determined to be more important than your personal history, your beliefs, your culture, your preferences. Or what if you weren't included in decisions about where you want to live, what medical treatment you want to receive, how you spend your money, etc. Well, that's what a conservatorship can do, all of those things, take away all of those those things that we take for granted, decisions that we make. So a conservatorship is as a result of a court proceeding in superior court. So in the state of California, we have superior courts throughout the state. Some counties have multiple superior courts because the counties are really big. So for example, Los Angeles County will have a number of superior courts. So when we're thinking about conservatorship and you're thinking, oh, I want to file a petition for conservatorship for this person, you would be going to your nearest superior court and you would be filing those papers in the probate department. So the probate department within the superior court handles conservatorships, whether they be full conservatorships or limited conservatorships, which I'm going to talk about later. So the person who is appointed to make these decisions for you is called the conservator. The persons whose rights have been taken away is called the conservatee. Usually the conservator is a family member, but it could be a stranger. It could be an organization. Public guardian could be an entity that's appointed as conservator. And so when we talk about full conservatorships, usually it's of the person. And what does that mean? It means that rights like health care, what to eat, what to wear, personal care, housekeeping, transportation, recreation, education, all of those things are decided by the conservator. The other part of the full conservatorship is conservatorship of the estate. So if a conservator is given conservatorship of the estate, then the conservator is handling all of the assets, locating and controlling assets, collecting income if there's income producing property, making budgets, paying bills, investing money, protecting the assets. So when I talk about full conservatorship, I'm talking about both conservatorship of the person and conservatorship of the estate. Sometimes people will file one or the other or both. It all depends on the situation. So why do parents think about getting a conservatorship? Because they've been told to do so, because when they go, especially when their child, perhaps with a disability, is about to turn 18 and they're concerned about the parent's ability to continue to make decisions for their child, and they talk to other parents, and maybe they talk to the school, the regional center, doctors, and everyone's saying, oh, you need to get the person conserved, without really understanding what that means. And we'll talk about that. The other concern that parents have is, well, what's going to happen? When my child turns 18, my child is now an adult, and I can't do anything. I can't participate in anything without my child's consent or a legal document that allows me to participate in this area of my child's life. So their concern is, well, what happens with healthcare? How am I going to be involved when I don't have anything legally that allows me to do that? Or concern about financial abuse. You don't want your adult child to be in that situation. Or how do I link my child to services if I don't have any authority to do that? We need to think of conservatorship as something that is never needed just because you have such and such diagnosis, or quote unquote, because you need help, or because that's the way that it's always been. Of protection with conservatorships, even if you get a conservatorship over a person, you cannot protect that person from financial scams, from physical abuse, sexual abuse, police arrest, and jury convictions. So conservatorship is not going to protect your loved one from that. Other risks of conservatorship: once the judge approves the conservatorship, it's pretty much a done deal. And it's very difficult to reverse that. There were some changes in California law about reversing the conservatorship that I'm going to talk about in a moment, but very difficult to do that. Reasons for undoing the conservatorship could be that the conservatee dies, so no need for conservatorship anymore. If you have conservatorship over the estate and there are no longer any assets, then you don't need a conservatorship of the estate because there are no longer any assets. Or perhaps the conservatee has suddenly regained capacity to be able to handle his or her own matters. There is such a thing as a temporary conservatorship. So sometimes people have temporary conservatorships because perhaps maybe they don't have the capacity at the moment to make decisions. But even aside from a temporary conservatorship, there may be occasions where the person may somehow regain capacity, but it's not that common. Now, once the judge agrees to the conservatorship, it's not the end of the court's involvement in this case. The court's involvement in this case is pretty much forever. So what happens is that after the conservatorship is granted, within a year or so, an investigator will go out and make sure that things are happening. Sometimes that doesn't happen, which could, this checkup, which has its own problems if it doesn't happen. And sometimes it does happen where the investigator goes and investigates, but that could also lead to problems. So for example, if you have a child who has autism and other disabilities, and when he's in the home, he likes to run around naked. That's common, no problem. One day the investigator comes to the house and for that appointment and sees the child running around. You're monolingual Spanish speaking and you can't really convey what's going on. Culturally, the investigator may not know what's going on. And the investigator may write up a report recommending that the conservator be changed. And also what could happen with conservatorships is usually it's a family member or family members that are appointed as conservators, because you can have more than one conservator. But the court doesn't have to respect the chain of succession. The court can change who becomes the conservator. Sometimes the court may appoint professional conservators who've never had any contact with your loved one who's been conserved. So it's not a full conservatorships are not foolproof. In making sure that the conservatee is going to be safe, that your decision to appoint certain people may be followed down the line. And guess what? Conservatees, despite the fact that they may have, conservatorship, have rights too, even after a conservatorship is granted. And I'm going to show you a form. This is a court form. You can find it online, and I've given you the link on the PowerPoint to this form. And it's a form that's given to conservatees about their rights. And we're going to get it up in a moment. I thought it was really interesting because people think, oh, I have this full conservatorship. The conservatee has no rights. So no, that's not the case. So this is the notice of conservatee rights. If you can is it possible to open it up a little bigger so that we can see, if possible? So it says here that when a person becomes a conservatee, the person who's being conserved, he or she does not necessarily lose the right to take part in important decisions affecting his or her property and way of life. Every conservatee has the right to be treated with understanding and respect and to have his or her wishes considered. They all have basic human rights, the right to be well cared for by his or her conservator. The conservatee has the right to ask questions and to express concerns and complaints about the conservatorship and about the actions of his or her conservator. The conservatee may ask the court to review the conservator's management of the conservatorship if disputes cannot be worked out between the conservator and the conservatee. And if we scroll down a little bit here, it says conservatee's rights. So after appointment of the conservatee keeps the rights to be represented by a lawyer, ask the judge to replace the conservator, ask the judge to end the conservatorship, make or change his or her will, directly receive control of his or her salary, and control an allowance. Now, if we scroll down to the next page, it says, unless the court has limited or taken away the right, the conservatee also keeps the rights to receive personal mail, to vote, to marry or enter into registered domestic partnership, to receive visits from family and friends, to make his or her own medical decisions, to enter into transactions, and you can read about that there, to engage in other activities the court expressly allows him or her to do at the time of the conservator's appointment. For a limited conservatorship, the judge, whatever rights the judge decides to take away, those are the only rights that are taken away and nothing else. So it says here, unless the court has limited or taken it away. And where are you going to find that information? Once the judge approves the petition for conservatorship, he issues letters of conservatorship, and it outlines what rights were taken away. Thank you, Maricruz. So we're going to go back to the presentation. And that's the link to that document so that you can see it. So, you know, it's not to say that conservatorships should never, are never, ever needed. They're needed sometimes in emergency situations where the person doesn't have the capacity to give consent, and the person didn't previously identify how decisions should be made in that situation, and there's no one else available in the person's life to provide consent through, like there's no power of attorney, there's no advanced healthcare directive or any other means. And also to support people who may face critical decisions and have never been given supports to make and communicate their own decisions. So, you know, but for a lot of people, a full conservatorship is never necessary. But it's something that people do because that's all they know. So why think about other options to conservatorship? Because the conservatorship takes away the rights to make important decisions. The court becomes both part of the conservators and the conservatee's person going forward. So for a lot of things, the conservator has to ask permission of the court to do so, like moving out of the state, for example, lots of things. The relationship between the conservator and the conservatee can change, maybe for the worse, because now the conservatee is not so happy about the decisions that are being made on his behalf. And conservatorships can take time and money. So what are the other options that we're going to discuss today? I'm going to talk about limited conservatorships, supported decision-making, powers of attorney, advanced healthcare directives, HIPAA forms. Advanced healthcare directives are here twice, so we'll have to take that one out. Special needs trusts, CalAble, joint bank accounts. I'm going to talk about all of these. Now, what you need to think about all of these is like tools in your tool chest. And you can mix and match depending on what the need is. But supported decision-making can be available to the person whether there's a conservatorship or not. It's not an either or. It's along with whatever else, supported decision-making can always be a part of all of this. So when you're trying to decide what's the best decision-making strategy, ask yourself these questions. What kind of decision needs to be made? How much risk is involved? How hard would it be to undo the decision? And has the person made a decision like that in the past? Ask yourself, what's the least restrictive support that might work for the person? Let's now talk about one of the alternatives to a full conservatorship, which is called a limited conservatorship. And this is only available to people with developmental disabilities. And there are only 7 rights that the judge in Superior Court can take away. So, and they're listed right here. So let's say that my mom files a petition for limited conservatorship in Superior Court, and she wants to take away all of these rights. She wants to take them away from me, where I live, to view my confidential records, to marry, to sign contracts, to seek consent to medical treatment, to control my social and sexual contacts, and to make educational decisions. She's checked those off in the limited conservatorship petition. Whether the judge does give her these rights and takes them away from me will depend on what evidence the judge has in front of him or her to decide whether I have capacity to make these decisions. So there are things that a limited conservatorship will not do. It won't allow the conservator to control my salary or allowance, to approve harmful medication, medical treatments, to force drug treatment, sterilization, force the person into an institution, to undergo electroshock therapy or psychotherapy. That's not what a limited conservatorship is for. It's only for those other 7 potential rights that can be taken away. So my mom files the limited petition for limited conservatorship. An investigator will be assigned to my case. This person is going to talk to me and tell me what's going on, decide if I'm in a position to attend that hearing when the judge is going to make that decision, whether I oppose the conservatorship, whether I oppose my mom as conservator and I want someone else. The investigator is also going to talk to other family members, determine if there's really a need for this conservatorship and whether the conservator is suitable. I know that you guys, someone is going to ask, well, how, before my child's 18th birthday, when should I submit the petition for conservatorship? I know it's going to happen, so let me just tell you, I don't know, because for several things. When I was doing a training on this, someone from the audience said that she filed on behalf of her son a petition for limited conservatorship. She filed it. And it took the investigator 8 months to complete his investigation. This investigator called people who lived in Mexico. I mean, it took a long time. So I don't know how long it's going to take the investigator if you're going to file for limited conservatorship or conservatorship, full conservatorship, because an investigator will be assigned. I have no idea how long it's going to take for the investigator to do his or her job in your case. Secondly, there are a number of superior courts, like I said, throughout California, and you're going to be filing these papers in your local branch. I don't know how backed up they are, what their calendar looks like for hearings. So you would need to call your Superior Court probate department and ask them, how far ahead are you scheduling these hearings? And that will give you an idea of, how soon you should be before your loved one's 18th birthday. You should be filing a petition, for example, for limited conservatorship. So I would suggest that you contact your probate department of your Superior Court and, How long is that investigator going to take? I don't know. And other people have said that it took less than 3 months. So it's hard for me to tell you how long how soon before the 18th birthday you should do that. And conservatorships can be approved for anyone 18 or older. You hear sometimes of cases where family seeks conservatorship over a parent and the parent is 80 years old with dementia. That happens, or it could be early on in life. It could be at any time during the person's life that someone can seek conservatorship over the person. So that's the investigator. I may be assigned an attorney too to represent me at this hearing. Other things that are going to happen is that the regional center is going to evaluate me and file a report with the court. And that report is going to talk about my disability, the type of assistance I need, my physical, mental, social well-being, and recommendations to the court about this petition. And the regional center has to file that report at least 5 days before the hearing. The report is confidential, but it is provided confidential to the public. It's not something the public can look at, but the parties will be provided with a copy of that report. Since I'm a consumer of the regional center, I can reach out to my Office of Clients' Rights advocate for that regional center so that that person can help me understand what's going on, talk about alternatives, talk to my attorney or my investigator about what I feel and what I want to happen. The Office of Clients' Rights is our sister organization. They are not employees of the regional center. There's a clients' rights advocate for every regional center and an assistant clients' rights advocate, so normally 2 people for each regional center, and they're there to assist consumers of the regional center or those who want to be consumers of the regional center. Again, I want to stress they are not regional center employees. They're there to advocate on behalf of consumers or people who want to be consumers. So that's a resource for me in this hearing. So in order to grant a limited conservatorship, the judge must determine by clear and convincing evidence, that's a high standard, that the limited conservatorship is necessary to promote and protect. So it's possible that although my mom checked off the 7 rights that she wants to take away from me, the judge may decide that the only rights that Maria should be taken away is the right to marry and the right to contract. And that's it. So, those are the only rights my mom has over me that I no longer have. I have all my other rights in a limited conservatorship. So what's the goal of looking at alternatives to conservatorship? The goal is to keep the person as independent as possible. Let them shape their own lives. That's called self-determination. And self-determination makes sense. Let them be the causal agents of their lives instead of being acted upon. And there have been studies that have shown that people who are disabled and have greater self-determination are more independent, more integrated into their communities, healthier, and better able to recognize and resist abuse. And those reports are listed here. So we've talked about full conservatorship and limited conservatorship. Now, a limited conservatorship can, in a way, be, it is an alternative to a full conservatorship, but it's still a conservatorship. Now we're going to talk about things that have nothing to do with the court. You don't have to go to the court to do these things. And we're going to talk about the first one, which is supported decision-making as an alternative to a conservatorship, whether it be full or limited conservatorship. So supported decision-making is an approach where the person with a disability ultimately makes the decisions, but with help from their circle of support. We do that as people without disabilities. We go to people when we have decisions to make. I sometimes consult with my spouse or my mom about things to help me make the best decision. So California has made supported decision making an alternative to conservatorship. It's in statute, it's in the law, it's officially an alternative to conservatorship. 20 other states have this in their laws. So rather than decisions being made for them, decisions are made by them. So for example, in my circle of support, maybe I've decided that I want my mom and someone, a professional I know, and my sister to be part of my circle of support. And I may go to them. I may decide I want to go to them whenever I have questions about things, or I need to understand something, or I'm about to make a decision and I need to know what the alternatives are to making a decision about something. They're there to support me in whatever way necessary. But guess what? I am ultimately the one who makes the decision based on the advice I get from my circle of support. Assembly Bill 1663 made supported decision making part of the law in California. So as of January of last year, not only did AB 1663 establish supported decision making in statute as an alternative, an official alternative to a conservatorship, it also says that petitions for conservatorship or limited conservatorship will have to include alternatives to conservatorship that were tried, if any, and why they are not appropriate. It requires the courts to provide conservatees information about their rights, that they retain that document that I showed you. And earlier I mentioned that there was a change in conservatorship laws where you can terminate a conservatorship without a hearing if both the conservatee and the conservator agree. If you want to know more about that law, you can go to this link and learn more about it. And I want to stress that supported decision making is not just, it's not just that's all you can use. That list of alternatives, like I said, there are tools in your tool chest. You can mix and match, but supported decision making can be available to the person with a disability, no matter what other legal documents are out there to give someone else authority over certain things. Let's talk about capacity for a moment. And that the legal capacity it refers to the person's ability to make decisions and to be responsible for their decisions and their acts. So we have to stop thinking about capacity as an all or nothing, or the person's capacity being based solely on their IQ or diagnosis. Because people may have capacity to make some decisions, but not others, make decisions sometimes, but not others, and make decisions if they get help understanding the decision to be made, supported decision making. So we need to think about capacity with supports instead of thinking of what can this person do alone and on a desert island. We need to think about what can this person do with the help and guidance from friends, families, professionals, technology, perhaps, education, patience, and practice. That's capacity with supports, supported decision making. with a little help from your friends, everyone seeks help with difficult situations. People without disabilities are encouraged to seek help. People with disabilities deserve the same. So we're going to see how supported decision-making fits in with financial decisions, educational decisions, healthcare decisions, and we're also going to talk about other alternatives other than supported decision-making to make these decisions, to help make these decisions for people. And none of this requires court intervention. You don't have to go to the court to, to get approval about who your circle of support is going to be for supported decision-making or for a power of attorney or for a healthcare directive. There's no court intervention with regard to these other alternatives to conservatorship. So when we're talking about healthcare, support is often required to understand the information you're getting from your healthcare professionals, to communicate perhaps with your healthcare professionals and or manage your daily needs. So if you have a circle of support to help you with healthcare, they can help you access healthcare, help you understand the information you're getting, and help you make decisions. They're not ultimately making the decision for the person, but they can help you understand what your alternatives are so that you can make the decision that you want to make. So supported decision-making and informed consent. Informed consent is really, really important in the medical context because doctors can't do things unless they've given the patient informed consent. So the doctor is giving the patient information to the patient. The patient needs to understand what the doctor is saying in order to make a choice and communicate that choice to the doctor. So when we're talking about supported decision-making, it could be to explain what the doctor is saying, what the treatment that is being recommended means to the person, explain to the person again what the doctor has said, and to communicate what the person wants to the doctor. So in these three steps, you could have your circle of support with you, explain what the doctor's saying, help you understand what the doctor's saying, and help you communicate what it is you want to have done. What are so along with supported decision-making, because you can have supported decision-making throughout, it doesn't matter, but you could also have a power of attorney, and the person can also have supported decision-making. So with a power of attorney, this is an alternative to conservatorship, and the power of attorney for healthcare in California is also known as the medical power of attorney. It's usually part of an advanced healthcare directive, and it's a legal document where the person gives another person that they trust the legal right to make decisions for them. So, for example, I can sign a power of attorney to my mom, giving her the right over my educational decisions, financial decisions, healthcare decisions, all the decisions. And so, and I need to have capacity though. I need to have capacity to understand the effect, the benefits, and the risk of what I'm signing. I don't necessarily have to understand all those fancy words in the power of attorney, but what I do need to understand is the effect, benefit, and risk of what I'm signing. So if I'm a person with a disability, and I have a cognitive disability, perhaps then as long as I understand the effect, benefits, and risk, I could sign that power of attorney, giving my mom powers to over certain things. Now, including healthcare. The thing is that just as I can give my mom the power of attorney, I can take it away from her at any time and decide that I want to handle all my affairs, or I want to give someone else power of attorney over my affairs. More about capacity is in this link, and you can read about it there. For sure, there are power of attorneys who have been signed by people who may not have had capacity, but they're being used, and as long as, and they're not being questioned. But some person down the line might question the power of attorney, and capacity is determined at the time that it was signed. So let's say, for example, I signed a power of attorney today, and I had capacity. I understood the effect of signing it, the benefits and the risk. And 10 years from now, I no longer have capacity. And 11 years from now, someone questions the power of attorney, because in year 11, I no longer had capacity. Because it happened in year 10 that I lost that capacity. But the capacity is measured at the time that I signed it 10 years before. So the power of attorney would be valid because at the time that I signed the power of attorney, I had capacity. It doesn't matter that later down the line, I lose the capacity. It's when I signed the power of attorney. The other way to assist someone with healthcare issues is to have that person sign a HIPAA form, a HIPAA medical information release form. So for example, let's say that my mom calls my doctor to ask for information, and the doctor's office says to my mom, well, we can't release that information unless we have a release from Maria. So my mom would say, okay, well, send me your HIPAA form, your release form, so that she can sign it, and we'll send it back. Typically, these healthcare providers have their own release forms, so it's just a matter of asking them for it. Again, I have to have, if I'm going to sign that, I've got to have the capacity to understand what I'm signing, right? What is the benefit, effect, and risk of signing this document? Giving my mom authority to get information from my doctor, and also participate perhaps in my medical care. I talked Advanced Healthcare Directive. Usually the power of attorney for healthcare is part of the Advanced Healthcare Directive. The Advanced Healthcare Directive is the form that gives another person the right to make medical decisions when that person no longer has capacity to do so. The typical example of that is, let's say I'm involved in an auto accident and I'm in a coma. I no longer have capacity to make medical decisions. So if I have an advanced healthcare directive, that advanced healthcare directive will tell the hospital and doctors who that person is who will make those medical decisions for me, because I no longer have that capacity. And note, this is a form of springing power of attorney, because springing meaning it doesn't come into effect until the event happens. And the event here is that I no longer have capacity. A general power of attorney comes into effect the moment it's signed. So usually with power of attorneys, you have to have two independent witnesses. Typically, if you're dealing with real estate, you have to have a notary. I've given you here a couple of examples of very simple advanced healthcare directives. Everyone should have an advanced healthcare directive. You don't have to have a disability to have an advanced healthcare directive, because you never know when something can happen and you no longer have capacity. My husband and I went to an estate planning attorney, and part of the estate planning included filling out an advanced healthcare directive, and our advanced healthcare directive was over 18 pages. And honestly, I don't remember everything that was asked, but I was surprised by the kinds of questions I had to answer, the decisions I had to make, like if something happened, what do you want your husband to do, right? Because he's the one that's listed as the person who's going to make those decisions. So, going to an estate planning attorney, they're also called elder law attorneys. They're also called wills and trust attorneys. They do this kind of stuff. You can just have the Advanced Healthcare Directive be put together, or you can do estate planning. What it is that you want to do when you're gone, and how do all your assets get divided, and all those kinds of things. We're talking about trust and wills and all those things. So an Advanced Healthcare Directive is really, really important. So let's talk about financial decisions. Sometimes, and with supported decision making, sometimes support is required to understand information, financial information, to communicate with banks, to manage your money. So that's, you could, as a person with a disability, and because I have supported decision making, I have my circle of support, I could go to them for these things. On top of supported decision making, other ways to deal with my finances without having a conservatorship, for example, would be to set up automatic payments from a primary account. The other way to do it could be, and combinations of all these things, right? It's not just either or, either this or either that or either that. You can use a combination of things. Perhaps my mom and I can open up a joint bank account where both of us have access to put money in, take money out. But in this case, especially if you're on another public benefit like SSI or Medi-Cal, you do not want to commingle. My mom and I don't want to commingle our funds. So it's really my bank account. My mom shouldn't be putting any money in that bank account. She's just on my account as a joint person to be able to manage my account. Very important. The regional center, if you're a regional center client, they have a service called supported living services that can teach the consumer, how to become more independent out in the community, how to access transportation, how to cook, clean your home, how to manage your money. So, it's something that and these services are available to consumers who are 18 or older. If the only thing I have in the world is my payment from Social Security, I don't need anything else, because my payment from Social Security goes directly into my bank, and my mom is my representative payee, and she's responsible to make sure that the money I get from Social Security is used on me, that I have a roof over my head, I have meals. In fact, Social Security will do an audit every year to make sure that the money is used for me, right? And so no need for anything else. I don't need a conservatorship. I don't even need a power of attorney if all I have is my Social Security benefit and my mom is my representative payee. For financial decisions, you can also have a power of attorney, but I'm just giving you options, and you can mix and match depending on your situation. The other ways to do things is some people through an estate planning attorney, trust and wills attorney, elder law attorney, they're all synonymous. They create a special needs trust where they put resources and money into the special needs trust. The trustor is the person who handles the trust, and that person will make decisions as to how the money in the trust is used. There are very specific rules as to how you could use the money in the special needs trust. I'm not an elder law attorney, and that's a question that you would have to ask that kind of attorney. The other thing that you can do in conjunction with a special needs trust, these, like I said, these are not either ors, these are mix and match. You can even set up, if you qualify to have an ABLE account in California, it's called CalAble, and we're going to put the link to CalAble in chat. So if you qualify to open up an ABLE account, and let's say that you're on SSI, The general resource rule with SSI as an adult is that you can't have more than $2,000 in countable resources. There are resources that are not counted, like the home you live in, one car, no matter the value. But so you can't have a lot of countable resources when you're on the SSI program, $2,000. But if you have an ABLE account, you can have up to $100,000 in your ABLE account, and it will not affect your SSI eligibility. So there are a lot of good things about having an ABLE account, especially if you're on SSI. And so if I open up a Cal ABLE account, I can make my mom the authorized legal representative. She will have control over my ABLE account. She's the only one that will have control over my ABLE account. And the money in the ABLE account has to be spent on qualified disability expenses. The definition for that is very broad. You can spend the money with that money. Maybe I can buy a condo or modify my home, buy a car, get education, take a vacation. Get a gym membership, hire an attorney, hire a financial manager. There's so many things I can do with the money in my ABLE account. So, and like I said, I can authorize my mom to be my authorized legal representative, and she would have sole access to the account and to manage the account. So you see, there are different ways to do this. In the area of education and supported decision making. So the truth is that many children with disabilities are not given the ability to make choices, and that leads to having little chance to learn from mistakes. And schools commonly promote conservatorship as the only option. And I think really it's because they don't know that there are other options. It's the only thing to say. It's really important to practice decision making. This is the supported decision making concept from the earliest age possible. You don't have to start supported decision making when the person turns 18. Ideas to practice supported decision making at an early age. The child should attend and participate in IEP meetings where appropriate as much as possible, because the law allows them to participate in IEP meetings. And the IEP goals, for those of you who don't know what an IEP mean, individual education plan, it's a contract between the student and the district, and it identifies goals and what services and supports are going to be in place to reach those goals, among other things. So when in the IEP, when you're thinking about the goals for the child, they should be ambitious, promote student involvement, target self-determination, self-advocacy, and problem solving. Don't just wait until the person's 18 years old to start teaching them how to do all of these things. You can do this from an early age. In California, the California Education Code, and you have the section here, allows the student, when the student turns 18, to sign a document allowing whoever they want, maybe the parent that has been always participating in IEPs, to continue assisting the now adult child in educational matters. There's a court website that has a document that the student can sign, and then you can just give it to the school. We have a manual on special education called the Special Education Rights and Responsibilities Manual. And in our Appendix P, there's a form that can be filled out and given to the school. Because what happens if I turn 18 today and there's an IEP meeting next week, and my mom goes with me to my IEP meeting next week, the school can say to my mom, you have no legal authority to be here, and they would be right. But my mom would give them this assignment of rights, and then they would have to allow her to be involved. So that's another way to do it. For educational rights, you can also, for educational rights, you can have a power of attorney, and a limited conservatorship will also allow the conservator to make decisions with regard to education if the judge agrees that that should be the case. I've included a number of resources for you to look at. There's a really good handbook from Disability Voices United. It's called Support Without the Courts, and it talks about supported decision making and other things here. I do want to take you to the self-help resource section of the California Courts website, just to show you what is there. Now, prior to COVID, some superior courts had clinics for conservatorship and limited conservatorship. So you could learn about the process, the forms that were used in either of these types of conservatorships. And then COVID hit, everything shut down. I don't know if all the courts that had these clinics still have the clinics now. You would need to call your local superior court to find out if they have clinics on conservatorships, including limited conservatorships. So in the self-help section, if we go up to self-help on the top left-hand, I have left-right issues, so I have to do this in order to know what's left. We scroll down to seniors and conservatorships. It's up here, seniors and conservatorships. Yeah, a little bit right there. Yeah. So you're going to find information on helping with someone with disability, helping a young adult with a developmental disability. They're going to be talking about limited conservatorships, special education. There's even a section about alternatives to conservatorship. So if we go back to the previous page, there should be, if you scroll down, you might have to just play around with the website, but there is a section on alternatives to conservatorship. I want to see something for a moment. Maria Cruz, I'm going to undo you for a moment. I'm going to go back to the resource page. I just want to see if, whoops. Oh gosh, okay. Okay, I'm going to do something. I'm going to Google something actually, if I can. California. Okay, they've changed this a little. Forms, let's see more information, self-help locations. Those self-help locations may be where you find the clinic information, type of case, conservatorship, options to help someone with a disability, general and limited conservatorships, step-to-step guide on a limited conservatorship, options, including to help with money management, making decisions. So there's a lot of information here. And I know that as you look, you'll find alternatives to conservatorship, which is basically the stuff that I went through. So we've come to the end of the presentation, and I'm happy to take questions.
Actually, let me just pause the recording. Thank you so much. That was, I know already the ones that I'm going to be printing out for myself with my